Greetings, guys. I wanted to talk to you about a recent development in Atlanta, Georgia. As I've expressed to you, everything is contract, and I don't have validation of this yet, but in Atlanta, Georgia specifically, they are going to start asking, but making it look as though it is required for you to sign away your rights to unreasonable search and seizures if you've been convicted of drug offenses, criminal activity, or alcohol and drug violations, and that's cause for concern. But again, if you don't know who you are and you don't know that you have rights and you enter into a contract of your own free volition with full disclosure, well then, such is life. But enough about that. Let's talk about the Trust Ex Maleficio notice regarding standing and demand for accuser attorneys' foreign registration for all attorneys holding bar cards. Demand is hereby made by Derek Chiton Gonzalez for whatever attorney, law firm, or attorney valid, authentic foreign agent registration to evidence plaintiff's attorney's standing. Okay? State of issuance of standing administrative notice 63C and jurisprudence 2D public officers and employees subsection 247. As expressed otherwise, the powers delegated to the public officers are held in trust for the people and are to be exercised on behalf of the government of all citizens who may need the intervention of the officer. Furthermore, the view has been expressed that all public officers within whatever branch and whatever level of government and whatever be their private vocation are trustees of the people, and accordingly labor under every disability and prohibition imposed by laws upon trustees relative to making of personal financial gain from a discharge of their trust. That is, a public officer occupies a fiduciary relationship to the political entity on whose behalf he or she serves, and who owes a fiduciary duty to the public. It has been said that the fiduciary responsibilities of a public officer cannot be less than those of a private individual. Furthermore, it has been stated that any enterprise undertaken by the public officials who tends to weaken public confidence and undermine the sense of security for individual rights is against public policy. Fraud in its elementary common law sense of deceit, and this is one of the meanings that fraud bears. 483 U.S. 372. In the statute, concealment of material information and setting of a fiduciary obligation. A public official is a fiduciary towards the public, including, in the case of a judge, the litigants who appear before him, and if he deliberately conceals material information from them, he is guilty of fraud. McNanny versus United States, 483 U.S. 350 in 1987 was the year. Issue 1, standing, public law 75-583, under Title 22 U.S.C. Foreign Relation and Intercourse, subsection 611, a public official is considered a foreign agent. In order to hold public office, the candidate must file a true and complete registration statement with the state attorney general as a foreign principal, and no such registration has been provided to Derek Chiton Gonzalez, confirming accusers' attorneys standing to litigate, act, or move on behalf of the plaintiff. Title 22 U.S.C. subsection 611 identifies all public officials as foreign agents, which are required to register with the Attorney General within 10 days under oath on a form prescribed by the Attorney General. Where no registration exists, no standing is possible. In addition, the 11th Amendment states, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of a foreign state. A foreign entity, agency, or state cannot bring a suit against a United States citizen without following proper procedure. Furthermore, Title 22 CFR 93.1 hyphen 93.2 through 93.2 states the Department of State must be notified of any suit and, in turn, has to notify the United States citizen of said suit, and as of the date of this writing, Derek Tom Gonzalez has no knowledge of the Department of State's being noticed, nor has said evidence been admitted. Under and in accordance with Title 28 U.S.C. 1330, it is the United States District Court to grant permission for any suit to be pursued once the court has been supplied sufficient proof the United States citizen is actually a corporate entity. Currently, no evidence exists, nor has evidence of such been placed in the record in the case before this court. There is copious proof that the prosecution and other agents are actually corporations. https://www.law.cornell.edu/US code/text/22/612. Title 22 U.S. Code, subsection 612, registration statement. Filing, it states A, filing. Contents, no person shall act as an agent of a foreign principal unless he has filed with the Attorney General a true and complete registration statement and supplement thereto as required by subsection A and B of this section, or unless he is exempt from registration under the provisions of the subchapter except as hereinafter provided. Every person who becomes an agent of a foreign principal shall, within 10 days thereafter, file with the Attorney General and duplicate a registration statement under oath on a form prescribed by the Attorney General. Registrant's name, principal business address, and all other business addresses in the United States or elsewhere, and all residence addresses, if any. 2. Status of the registrant, if an individual, nationality, if a partnership, name, resident address, and nationality of each partner, and a true and complete copy of its articles of co-partnership. If an association, corporation, organization, or any other combination of individuals, the name, residence address, and nationality of each director and officer and of each person performing the function of a director or officer, and a true and complete copy of its charter, articles of incorporation, association, constitution, and bylaws, and amendments thereto, a copy of every other instrument or document, and a statement of the terms and conditions of every oral agreement relating to its organization, powers, and purposes, and a statement of its ownership and control. 3. A comprehensive statement of a natural or registrant's business, a complete list of registrant's employees, and a statement of nature of the work of each, the name and addresses of every foreign principal for whom the registrant is acting, assuming, or purporting to act, or has agreed to act, the character of the business or other activities of every such foreign principal, and if any such foreign principal be other than a natural person, a statement of the ownership and control of each, and the extent, if any, to which each such foreign principal is supervised, directed, owned, controlled, financed, or subsidized, in whole or in part, by any government of a foreign country, a foreign political party, or by other foreign principals. 4. Copies of each written agreement and the terms and conditions of each oral agreement, including all modifications of such agreement, or where no contract exists, a full statement of all the circumstances by reason of which the registrant is an agent of a foreign principal, a comprehensive statement of the nature and the method of performance of each such contract, and of the existing and proposed activity or activities engaged in or to be engaged in by the registrant as agent of a foreign principal for each such foreign principal, including a detailed statement of any such activity which is a political activity. Accuser's attorney must be determined and demonstrated approved and in compliance with and under Foreign Registration Act, FARA, of 1938, for accuser's attorney to legally and lawfully represent any party or participant in any and all capacity, those holding federal or state public offices, county or municipal offices under the legislative, executive, or judicial branch, including court officials, judges, prosecutors, law enforcement department employees, officers of the court, and etc., before entering into these public offices are required by the U.S. Constitution and statutory law to comply with Title V U.S.C. subsection 3331, oath of office. State officials are also required to meet this same obligation according to the state constitutions and state statutory laws. All oaths of offices come under Title 22 CFR Foreign Relations section subsection 92.12 through 92.30, and all who hold public office come under Title 8 USC section subsection 1481. Loss of nationality by native born or naturalized citizen, voluntary action, burden of proof, presumptions. The oath of office requires the public official in his or her foreign state capacity to uphold the constitutional form of government or face consequences. As of the date of this writing, accuser's attorney has not filed in court their standing to represent or act on and in behalf of the plaintiff, defendant, or respondent. Therefore, this court may not move forward in ruling, decisions, declaratory judgment, or decree until said standing is resolved in, on, and before this court to the satisfaction of the referenced in caption herein under and in accordance with the Foreign Registration Act of 1938. Derek Chiton Gonzalez herein asserts legal and lawful notice and demands accusers' attorneys demonstrate standing, ability, eligibility, and right, if any, to act under the code, statutes, public laws, statutes at large, federal statutes enacted, and federal acts. In addition to public policy, be those authorities local, state, and federal in this or any other court in the United States and or any state therein. Without said evidence, accuser's attorney on or in behalf of the plaintiff's legal representation is invalid, nullified, and the instant case must be dismissed absent standing, and I would move to vacate. Furthermore, accuser's attorneys enjoy no right to act, represent, move this court or any other court or tribunal and or on behalf of any entity for that matter until such time as valid registration has been reviewed for authenticity and found to be reliable by Mabry and this court, and therefore, absent this evidence, accusers must withdraw until said valid registration for the duration of the above referenced court matter is evidenced. Title 22 U.S.C. subsection 611 ET-SEQ United States Code and Title 28 CFR Part 5 Judicial Administration clearly expresses the requirements in pertinent part. Person acting as an agent of a foreign principal to make periodic public disclosure of their relationship with the foreign principal, activities, receipt, and disbursements of those activities. Conclusion and rectum rogar. The facts in the law contained herein and the truth, and we hold said truths to be self-evident, and self-evident truths are undisputed and incontrovertible. No oral argument is requested, for no words can alter or overcome these truths, and the truth is sovereign. He comes from God and bears his message. From whatever quarter her great eyes may look down upon you, Psalms 117, full colon 2, John 8, full colon 32, 2 Corinthians 13, full colon 8. Please provide foreign agent registration information, bar membership identification, W-9, bond and insurance information, trust contract for said debt account, license for the said attorney, license for the said law firm. Please take additional notice. All responses must be done on and for the public record and must be signed with a wedding signature in the format of an affidavit with a public notary signed and sealed and Jurat stamp affixed. All other forms of communications will be null and void and will be used as prima facie evidence in any and all legal recourse I so choose to take as the authorized representative for Derek Chaton Gonzalez, the all caps name. I declare under the penalties of perjury in accordance with the laws of the United States of America without the United States, Title 28 U.S.C. subsection 1746(1), the foregoing is true and correct and is admitted when rebutted, so help me God. I hope that helps you out a little bit, and I hope you enjoyed that. It's just one tactic to expose the truth within the court. Remember, they're going to be really quick to dismiss the allegations against you once you start coming at them through the banking side of things, because that's what they're really after. They care less about your FRN notes, people. The court system manufactures or brings into existence well over $10 trillion a year in stocks, bonds, certificates, and securities. So with that, we'll close out with